Fantastic. Welcome back, everybody. Did everybody get enough coffee? Are you caffeinated? If you're caffeinated, raise your hand. Caffeinated, that's fantastic. All right, so I want to just get two takeaways of how did the morning go. All right, so where's Dave Reed? Dave, if we can get a mic over to Dave Reed. Dave, if you'd stand up, tell us who are you, where are you, and what came up for you in the morning session.
Sure, thanks. My name is David Reed. I'm a Director of Practice Operations at Honigman. And as we were chatting at my table, we were discussing the idea that the concept that Connor had raised of electricity. I think that was a powerful sort of image and concept that, how do you use electricity? And we realized that our thinking was wild and not directed at all. And so in the morning session, in the panel, it started to put some context around that. And, how could we be thinking? What kinds of things could we be, addressing our thinking towards?
Yeah. Do you know Sandra from General Motors?
I do not.
Yes. This is Sandra from General. She runs legal operations at GM. She's gonna tell us what came up at the GM table.
Fantastic.
Sandra, who are you and where are you and what came up at your table?
So yes, I'm Sandra, legal ops. I do not run it.
Raise and a promotion right here. You'll come back. Anybody who takes a microphone, you get an automatic raise and promotion. Well, you get a promotion. I don't know about the raise.
So we are, looking at using AI, and one of the things I do is for writing. So anytime you write something to people, they ask more, like when he put up on the screen, why, or, give me more. Something like I have to write instructions for people, and sometimes it comes off a little harsh. And so then you can say, take this and write it in a more professional, maybe use a happy tone. And sometimes it comes across with words that you're like, yeah, I'm not saying that. But overall, it changes your tone, and people have responded, noticed the differences in the communication. So it's helpful for that.
And are you using ChatGPT for that?
Yes, internally.
You use chat. And how often do you find yourself, how many times a day?
I use it several times a day.
Several times a day?
Yep.
Fantastic. Mm-hmm. Sandra, do you know Tom?
I do not.
This is Tom. What are we?
Welcome, Tom.
Hi, Sandra. Nice to meet you.
Tom, who are you? Where are you? What are we doing on this panel, by the way?
Yeah, well, I'm Tom Appledorn. I'm an IP attorney at Honigman, and I work very closely with our corporate group on commercial M&A, all transactions relative to that include a technology component, which today is all transactions. I also work pretty closely with our IP group, most specifically patents, and I'm really excited for our discussion this afternoon at 1:30. For any of those here who are interested, do attend. I think it's going to be a great discussion.
Yeah.
Well, what are we doing today?
What's this panel going to do?
I
don't think you need me. There's only 4 seats. I think that I've been bounced from this.
David, I'm the only one that didn't bring my notes up, so I'm not prepared for that question. I'm here for an informal discussion, but I think Carl can tell us.
Carl, I'm going to let you take it away. How does that sound?
All right, I guess I will. So I'm Carl Hokemer, a partner in our commercial group in the corporate department. And basically what do I do? I've been working with clients, both customers and vendors, on technology acquisition projects for close to 30 years. So I've been in this space in technology acquisition in particular for a really long time. And so what are we going to talk about today? I'm here just frankly to give everybody sort of an overview of how from the legal perspective, we approach a project where clients are asking us to help them acquire, license generative AI technology. And my picture is really old. So Danielle?
Yeah, so in order to help us kind of go through this, we thought it'd be useful to set the stage. So we're gonna have a case study today. We have a fake client, it's a marketing company that has come to us with the desire to use some kind of generative AI tool to create content for their clients. And so we're gonna go through a couple stages, first through how do we evaluate and help our clients evaluate these tools, and then how do we help them acquire them, actually negotiate those agreements, which is super fun. And then we'll talk about how they use them and how we advise on best practices.
Danielle, before we start, who are you?
I am Danielle Bass, and I'm a partner in our commercial group. I focus my practice on the commercialization, use, sale of any kind of intellectual property, information technology, and I also help lead our media and entertainment group. And then we might as well here introduce Steve.
Yeah, since we've gone down the line. My name's Steve Wernikoff. I'm in Honigman's Chicago office. I co-lead Honigman's data privacy and cybersecurity group, which, like probably everyone's group on here now, can be called an AI group, but do work, very closely with the rest of the folks on this panel and with clients involving all the sort of evolving issues concerning data privacy and data security and how AI fits in.
So Danielle, before you dive into this, there's a couple things I wanted to add.
Yeah.
So, backing up a bit, we heard the last panel talking about legal GAI technology, and there's proliferation of these companies that are offering GAI or AI-enabled tools just in the legal industry. But if you look at the economy as a whole, that proliferation is happening in pretty much every sector. So there's just a lot of different tools out there from a lot of different companies that do a lot of different things. And they're all at different maturity levels, quite frankly. So, we're lawyers, so we look at the terms and conditions. And you get to some of these larger providers, like Harvey, for example, they're buttoned up. Microsoft, they're buttoned up. Thomson Reuters and CoCounsel, again, they're pretty buttoned up. But when you start looking at some of these smaller companies and really diving into what their technology is, how it's designed, how it integrates with the LLMs, how data is protected, it's the Wild West.
I'm going to
And so
really to waste that.
the purpose of this discussion is to talk about some of those issues. There really is no standard. So, it's not one of these things where somebody can send an agreement for one of these tools to us and say, please review and let us know what's not market.
So good. No.
I can't really do that. Or let me know if you see any issues. Well, as you're going to hear, I've got a million issues that I can come up with. What I need to know is what's important to my business client, what's important to the users, and how is this tool going to support whatever the end use goal is. That's a lot of information, and that's more than I would need to know if I was just evaluating, a simple SaaS, type of service, which is more standard.
Just to cut in there, I heard Toby from our earlier presentation from DV8, I think, mention a process between Perkins Coie and 7-Eleven that they used to, I think, kind of procure some of that information. I think that's really interesting, and I think that would be a good use of an AI tool or other software product that could help us get that information in an efficient manner and avoid those 12 emails or 2 hours of phone calls with 3 lawyers on it to help streamline that process. And that's a tool that we're using or we're thinking about and have talked to Esther about in her team.
Right. And so the last thing before I hand it back over to Danielle is we've been talking about GAI tools that are really producers of text. But that's not, what they're limited to. So, there's all sorts of, video content and all sorts of other types of outputs that these tools can generate, which then brings a whole, another set of considerations on board. And then finally, a lot of what we're talking about is sort of business to business use. When you are talking about using GAI in a business to consumer context, and this is something that Steve in particular is very focused on, again, there's a whole additional layers of complexity. And now this really is the last assumption. And we're only talking about the US here. So we're not even going to start getting into, the AI directives and all that stuff that's going on in Europe and other places. So now I'll stop.
That's all good setting the stage, which goes very nicely into our discussion on how we evaluate some kinds of generative AI tools. So like any good lawyer, when a client calls me up and asks me a question, I ask them a bunch of questions. So these are some of the things that are going to be coming out of our mouths when a client comes to us asking about GAI tools, which is first, how comfortable are you with the provider? Like Carl mentioned, there's a wide range of providers out there, some who are super sophisticated and some who are just flying by the seat of their pants. We're going to want to talk to our clients about have they evaluated the track record, reputation, and credibility of some of these folks and understand whether they're the best suited partner for this project. We're going to also, depending on the use case that we're talking about, wonder if information technology teams, vendor diligence teams, data security, privacy folks, internally, assuming like there's a sophisticated structure there, have also, kicked the tires on who that vendor is and move forward.
Let me just pause you there, Danielle. In that case, I think it's really important for a user or an entity that's going to use the AI tool to really understand how the tool will be used and ingest any data that's uploaded into that tool. For example, when we're talking about trade secrets, I have an obligation to use reasonable efforts to preserve the secrecy of my trade secret. And so I don't want to, have a situation where a later a misappropriation of my trade secret occurs, and someone can say, "Hey, look, you used an AI tool. We have evidence that you loaded that data into the AI tool, and you did nothing to figure out or better understand how that data is being used. And AI tools are being trained on data, and perhaps the agreement covers that or doesn't cover that." And so I think it's important to keep records of what level of diligence, what level of understanding your folks have relative to the sophistication of the AI tool and the security around it.
Yeah, and we do this for two reasons, asking all the questions. One is, for prepping and teeing us up for what will eventually be the negotiation of the acquisition of the AI tool, but also as just a preliminary matter, like, is this a deal that we want to go through with? Is this a deal that the client is actually interested, after understanding like all the various risks, wants to proceed? So that's a really good point.
Yeah, I think just to kick it over to Steve on the data part.
Oh, you are kicking it to me?
Yeah.
Okay, good. So there's a couple things that sort of spin from that on the data side, because obviously tons of data is involved in AI. It's the core, sort of the engine that's driving AI. And so one of the first questions is going to be, like, what do the terms say? In evaluating the tool, you want to know, what do the terms say about how they're going to use the AI that you consider to be sort of under your control. And I guess to Carl's point a little bit, depending on the company, I mean, you really do need to look at the terms. The company may say, we're never going to use your AI for this or that or the other, we're never going to use your data for this. But you really got to look at the terms and have a comfort level that they're actually not going to use it, because your data may not be treated in a confidential way. So there already have been reported experiences where big companies have put confidential data into AI tools, and other people then in the future have run prompts, and that information that was confidential to one company has come into the answer and output of a prompt for another company, which obviously you don't want to have happen. And beyond that, a company may find itself sharing information or disclosing information with third parties that's inconsistent with what they said they were doing in their policies or publicly to consumers. So that's one thing. And then the other reason to sort of know what your uses are up front is that the way that the regulations are sort of scoping out now is there are some use cases that are more likely to trigger regulation. And those are involving a number of privacy laws that are focusing on automated decision-making that is where AI is used for a significant decision, right? And what is a significant decision, I think, is what it's going to be focused on over the next year or so. But right now, it's things like, if you think about it, if any of you travel in sort of the Fair Credit Reporting Act world, things like insurance, loans, lending decisions, employment decisions, things like that. Housing decisions, potential education decisions, things like that. If this tool is being used for those purposes, you're going to have heightened obligations, and some of those heightened obligations are going to include potentially opting people out or opting them out of being used in this tool. Or even the California regulation now would require you to provide access to the output of those individuals. So in evaluating the tool, going in from the beginning, you really need to know, is this tool going to allow me actually to comply with these obligations that I may have, right? And particularly in those, again, sort of significant decision areas, you want to be mindful of that. And you particularly want to be mindful also if you're flowing sensitive data into into the tool or into the service. And sensitive data also is sort of expanding a little bit, right? So certainly it would be things like health data and financial data, but regulatory agencies are expanding their concept of sensitive data to include things like precise geolocation or, let me think of other situations, browsing data. Browsing data, recently the FTC had a case involving. So you don't generally think of that as something being sensitive, but when run through your AI, you may find yourself in more of a regulatory framework than you thought you were in.
So just to spin it back to our case study here, where the marketing agency is providing or generating materials for its clients, presumably the client, they may want to load their client data into the tool.
Yeah, actually, I'm glad you brought that up because the California regulations now also consider profiling for behavioral advertising to be a sort of significant decision. Now, those regulations haven't been finalized yet, but even this scenario that we're talking about here, where the information is being run into the system for advertising purposes, if the idea is actually to be profiling individuals, to send those individuals targeted advertising, you actually may find yourself in this sort of heightened regulatory situation where you need to opt the users out, or you need to provide them with access to their information. And again, from the very early stage, you need to know really before you're putting the information into the tool whether you actually can comply with those obligations.
Yeah, so big picture obviously is asking, how are we going to be using the tool? Is this going to be our own team members? Is this going to be spread through to the clients to be able to leverage themselves? And then asking what kind of information, data, materials, videos, likeness, anything that's going to be put into the tool, we need to kind of create that circle Venn diagram. That's going to be your inputs, and understand we're going to be giving a license in that eventual agreement to the generative AI provider to use it in a certain way. And so we want to make sure that we are buttoned up on the protections there. So like Tom mentioned, trade secrets, even from like a legal perspective, we don't want to be putting anything that's potentially privileged into the tool because we might be inadvertently waiving those privileges. We don't want to have material non-public information if we're a regulated agency. We don't want to put any kind of personal information. Another thing we probably don't think about is, are we inputting information that we're subject to confidentiality obligations or have licensing restrictions on? So for example, a lot of outputs might not give you the right to commercialize or use those in other capacities. If that's the case, even putting an output from another AI into the input of a new AI could be breaching your obligations under those agreements. So really understanding what's in that Venn diagram, and then asking what's going to consist of that output. So what are we going to be getting? Is it going to be decision making? Is it going to be any kind of materials? How do we plan on using that? Do you want a license to use it? Are we just going to have like a back office use? Is this going to be just for internal business purposes, compiling information? Or are we going to be creating something that we then want to pass off to clients or other counterparties that are going to be creating derivative works or being otherwise modified?
And what are my obligations in those client agreements, right? Do I have the requirement to pass on ownership? And how will they be using it, and am I securing enough rights from the AI tool itself to allow that use, and how do I reduce the risk of that subsequent use? But I'm getting ahead of myself.
No, as we do. And so kind of riffing on your decision making, one of the big questions here is, how is the AI tool trained? So are you going to be receiving this generative AI tool that is completely out of the box, ready to go? Or is there an expectation that this marketing company, who has its own kind of tone, style, energy, is going to be inputting things to train it so that whatever the output is going to reflect that information? Obviously, it's way more expensive to train your own tool. But it's way more risky to receive a tool that has been trained if you don't know what kind of data has actually been put in to train it. So not only from a biases perspective, but there's a lot of information that could come with various risks. Like if there is already personal information inputted in there, if it's received information scraped from the web, if it's received information from research studies that are limited for non-commercial use, for example, things like that. Do you have any thoughts?
Well, I mean, I would jump off that just to also talk about the data security aspects of it, because you mentioned that this product or service, may be available locally, it may be available in the cloud, and I think some folks maybe don't realize, particularly if they're dumping their own company data into it, that it should be treated, and I'm sort of looking at Craig, our amazing IT lead, that there need to be data security protections around that, and treating it as if essentially it's another sort of core database almost of your company. So, including all the access controls and, potentially encryption or things of that nature, if again you are utilizing, your own data or particularly sort of sensitive data in the tool or service.
So on this topic, this is one thing that I see quite a bit, and I kind of call it the third-party, fourth-party diligence. So you're working with the vendor, you're talking about security, privacy, you're working on your DPA, and you start asking
What's a
questions.
DPA?
Data processing agreement. And you start asking about the vendor's sub-processors, and what do they do with their sub-processors? And oftentimes you kind of get this look, well, I don't know. And then, it leads to the question of, okay, let's talk about your third-party LLM providers. What are your agreements say, with respect to now all of its privacy, security, training? And I can't tell you the number of times when you push on that topic, you find out really what it is it's just an API to some publicly available GAI tool. And that's what's, powering this particular tool. So you have to, when you get into this issue of, privacy, data security, training, no training, you really have to push on again, the subcontractors and the subcontractors. My experience with providers is that when they can answer those questions right up front, and they can back it up with solid documentation, you're dealing with somebody who, again, is pretty buttoned up, but again, there's lots of them that are not.
It seems like I'm hearing a lot of hang-ups right now that we have mentally, a lot of mental processes going on. I do want to make it clear, we get these done, right? We get these deals done, and these are risks that it's an educational discussion with our clients. It just requires a lot of socializing.
But it's part of this due diligence process. So, if you're a big company like GM, you've got people who do this, right? But, we have a lot of clients that don't have those resources. And so to a certain degree, they're using the contracting process as the due diligence process. So that's, why I say when we get a project coming in, we have lots of questions.
Yeah. So we spent probably half of this discussion so far just talking about the questioning. So we'll get to the actual agreement part.
But it just shows that you really do, it really is helpful to think about some of these things before you jump in, right? That's the point. So at least half the time should be thinking about it and thinking about some of these issues, feeling comfortable instead of having to undo everything.
Right.
You realize they can't comply.
This questioning process, we were talking about efficiency a little earlier. This really drives a lot of inefficiency and puts time into the contracting process, right? A lot of people just think, well, you just read the agreement, it's only 3 pages. Well, what they don't realize is that it's linked to 350 pages of online terms, as well.
Or it just says it's as is, whereas go ahead, use it, but we're really not standing behind anything.
That's true too.
Right.
So, all right.
So we could probably spend, our entire conversation talking about all of the things that we would be looking for on a checklist item, item by item in a generative AI tool, terms and conditions. We're all super nerdy on all of those things. We won't get into the weeds a bunch, but we put together this slide, and Carl's going to go over just the top macro things that we're going to be thinking about as we approach this agreement.
Again, part of the questions are what are we trying to do? How are we trying to use it? So you've got to look at the agreements to make sure that the permissions, the use rights match. Again, these are sort of new. There's different ways of using these tools. What's included? Training, support. We've talked about data and ownership and usage rights. That's actually a really important piece of this, right? So there's, inputs, which is, materials that the user is putting into the program. You've got, kind of outputs. Again, what are those? Who owns it? What sort of protections or promises or warranties does the user need based on their use case? For example, if I'm a marketing agency and I'm getting output, but the terms and conditions say that I don't have ownership or I have incomplete license rights, how can I meet my obligations to my customer? Where my agreement says probably it's work made for hire, the customer owns it.
But don't the typical AI agreement says that you own the output. We just can't guarantee that, as between us and you.
Yeah, as between the parties.
But we as between anybody else, there might be a concern because obviously we're trained on third-party
Right,
information.
and oh, by the way, we're not making any promises about,
That's right.
that the output does not infringe.
So if I'm going to have an externally facing use, like my marketing company transfers a trademark or advertising material to its customer, and that customer intends to go use it, maybe we're okay on a contractual standpoint because I also disclaim to the customer in my contract that it's as is, whereas, and you need to clear it. But next thing I know, there's a third party saying, "Hey, look, that infringes my rights, my valid IP rights," and so I've put I've put my business relationship with that customer at a risk, despite having the legal protections in place.
Right. So we've kind of mentioned, right, there's reps warranties, indemnities, limitations of liability. I mean, for a lot of these, frankly, the approach is really to get the best you can, right? I mean, we all know that, technology vendors, tend to, limit their liability exposure. But really importantly, aligning with data protection laws, making sure that the contract appropriately addresses information security. Those are really, really important, sort of topics. And again, a lot of the big providers, I'm not saying that they promise the best, but they, by and large, it's okay. But again, you still need to go through the exercise.
Yeah. So in our example here, making sure if we're going to be using this marketing tool internally, obviously that license is just for us, but if we're passing that through, making sure that our end users, our end customers have the necessary license rights, making sure that we're identifying all those input materials as owned by us, any kind of improvements, modifications, enhancements, those still remain our clients. The output, all that remains the clients. If they want that to be owned by them, make sure that they have the necessary rights to use those. And then trying to allocate liability really the best that we can. It's going to be super unlikely, like Tom said, that a provider is going to say, yeah, we're going to indemnify you for any kind of IP infringement from those outputs, because most of the time, unless those materials are being trained exclusively on our clients' training data, there's going to be some other stuff in there. And then understanding what that means for your client. So if they're just going to be using it just to fix the white paper problem, and then they're going to riff off of it, they're going to make modifications, maybe this is a very moot or low risk issue. If they're going to be just passing this tool off so that their clients can kind of create copy on their own, and it's meant to kind of replace a human, it's going to carry a lot more risk.
Yeah, and on that, not just from the risk standpoint, but from the protection standpoint, right? Okay, I've conveyed ownership to the extent I own it to you, but what does that mean from an IP standpoint? If it's a, and we're learning, right? The prior two the directors of the U.S. Copyright Office disagree, but as the law currently stands, what the human contribution part of a copyright is only that part which can be copyrighted. The patent laws, or the patent office has done a good job, a pretty decent job, I should say, of starting to create policy on the protectability of patents or inventions generated through an AI tool. Again, 1:30 today, they're going to talk about it more. But we have to be realistic about the perhaps unprotectability of a lot of the AI-generated content, at least in the United States and in most of the world, though there are outliers like the UK, who does have a framework for which you can protect the copyright on AI-generated materials.
On acquisition, I would just say a couple things too that I think are important. So we sort of talked about the evaluation stage and all the questions you have to ask, and then once you've decided on some tool or service, I think of acquisition of like going back and setting up your governance framework, setting up sort of like your structure and your first principles as to how you're actually going to use this product. And so that involves policies where you're providing instructions on who can use this tool, how they can use this tool, what's the limit of use of tool, and testing the output if necessary, maybe testing the output for biases depending on what, just putting this all into policies so that you have a structure for use of this tool. Training your folks oftentimes is really important at this stage so that they understand how to use it, right? You may have the greatest tool, but they also understand like the proper use of this tool and the proper use of the output of the tool. Are they allowed to use the output of the tool for all purposes? Are they allowed to share it externally? All of these things are really helpful to have, again, sort of as first principles at the beginning as you're acquiring this product, as you're pushing it out to your employees and to your team.
Yeah, I've got one thing to add on that. So this is really addressed to the Honigman people in the room. So what Steve talked about is actually super important. And so, from the law firm perspective, right, we've done this for our own business. And so, we have different tools that are out there for people to use in different use cases. And again, that is governed. I mean, and it's subject to a policy, and we're out there internally educating people about those policies and how these tools should be used. And sure, yes, we have the ABA ethics opinion and all that other sort of stuff that applies to us. But that concept and those concepts really apply to any business, right? I mean, you go through this exercise, you do this assessment, you go through the negotiation process. You need to monitor the use. There needs to be policies, because
Do people follow policies?
I think people do generally follow
We do.
Well, you need to have consequences if they don't follow the policy.
Yeah,
Right.
but I do think for the most part, people are rule followers, right? And especially if it's a reasonable set of rules. But they are important because
How often do we find use of AI tools, because I know we have logs, use of AI tools that are being used in a manner that, and not to put you or us on the spot, that don't follow the policy?
I'm not aware of any red flags that we've seen. But again, any company, right? So you have to be careful. Again, thinking about all of these things. I mean, any one of us can have ChatGPT on our phones, and it's our personal license or a free one, and we're using it for inappropriately, I would say. I mean, that's a challenge, and that's just reality, I think, for any business, whether law firm or not. But again, this education and training, I think, is really super important, because I think, especially like with my kids, I mean, they don't think about any of that. They just use it. So that's takes us off to use, I guess.
David, I see a burning desire over there.
We have a burning desire because I know there's a question from the audience.
Great, let's bring them on. Yeah.
And then I know Steve's going to take us to Eric, and we're going to be talking about the FTC and compliance. And so, great job. Is there a question that comes up from the audience? Did something get triggered somewhere along the lines? Because otherwise I have to call on Angela again, and that's not right.
You sat in the wrong spot
Another
today,
promotion.
Angela.
You have so many promotions by the end of today.
By the way, there is a GM, there's a Yukon downstairs, and there's also a Suburban that we're auctioning off, if I remember correctly. Oh, no, it's not that. Questions from the audience? Dennis Kennedy for 200.
I'll ask one. So from where you're sitting now, I mean, a lot of these vendor agreements are going to go back to the big tech companies and the big AI companies, where presumably not many people have much, if any, leverage. So I'm curious, what specific areas are you finding in these negotiations that you're able to get changes to terms? Or are we essentially in the equivalent of a click-through world with some of these agreements?
I think for me, table stakes are you get some kind of performance warranty. You're going to get your SLAs. They might not be your 5 nines, but you're going to get something. You're going to understand what uptime is and what those downtimes are going to be. You're going to understand how the tool is going to hopefully be used, what the data is coming in, who owns the data coming out, modifying that to the extent as possible. One area I see some movement on is like feedback and usage data. So, we talked about those two Venn diagrams of like what goes in, what goes out, but there's also the information about like how people are using the generative AI tool, the feedback, the information that the clients or the customers are giving those generative AI providers, and who owns that, how it gets used, always getting confidentiality as it relates to like any kind of identifying factors, of course. And then IP infringement, as it relates to use of the tool, I think is pretty much table stakes as well right now. Limitation of liability is always going to be kind of a fun
catch-all, right?
endeavor. Yeah. But I think right now those are reasonable expectations. If that's not what's in the agreement, that people are willing to move on.
Which is not really unlike any of the cloud agreements that we work on, right? The Amazons, the
Microsoft.
Yeah, right.
Yeah, but even so, like even like a Microsoft, they want people to adopt their tools, and they're trying to sell these tools to large enterprises, and they're different than they used to be 10 years ago. I think they do move a little bit, and they do provide some protection. I mean, they've come out and said, with respect to Copilot, we think that there's no way that any output that is generated by Copilot is going to infringe somebody else's copyrights. And they say they provided indemnity. They do back that up to some degree in their terms if you dig for it. Microsoft too, you can push and go through this exemption process so that they will not subject your content in Copilot to human review. You just have to know, with the big providers, you just have to know where you can make those types of asks. In the legal tech GAI world, like I said, the big providers are pretty buttoned up. They really want to sell their stuff to big law firms, and guess what? Law firms tend to read their agreements. So, but where it, again, it's more difficult with the smaller providers. But again, I've had a great success, with talking to the small provider and say, look, you need to know who your customers are. You can't have bad contracts if you're trying to sell to, law firms. And I've seen a lot of movement there. Another thing that's happened a lot is you sit through these sessions on these tools, and they talk about, we don't train on your data, blah, 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 blah. You get the agreement right there in the license provision. It says, oh yeah, they train on our data. So, there's some, veracity issues, I think, in this space as well. But you definitely can get some movement in the contracts there.
I think at this point, one thing that might be interesting to make note as a bright line. There are architects. These are architects and implementers of solutions. They're architecting and they're implementing. So when you're listening to who's out there, it's not a cacophony of sound, right? They're becoming quickly, if they aren't already, subject matter experts on the architecting of a solution and the implementation of this technology on your behalf. The first panel we had up that I was speaking with, they were the funders and they were the founders and they were the inventors of the technology. These are the architects and the implementers. And if you're general counsel, you're a responder to that. You're responding to what's going on. But these are your architects and your implementers. So thank you very much. Great job.
Thank you, David.
Thank you.
Thank you.